Hello, everyone, and welcome to Blabbit. It's great to see you aboard here in our weekly podcast. For those of you who are new to the Blabbit universe, what we do here is we have a nice conversation with various experts, and they are kind enough to share their insights, their tips, their advice, their to-dos, their not to-dos with us and with you. My name is Paul Geiger. I am one of the co-hosts of Blabbit. I am also a public speaking coach and presentation expert out of New York City. And I work with individuals and organizations to make sure that their messaging is clear and that they're comfortable and confident in delivering that messaging. There's a lot that goes into it, but for each person, it's an important skill, an important thing that you need to know how to do. Good to see you, Glenn. How are you this morning?
I'm well, thank you, Paul. Great to see you as well. Hey, everyone. My name is Glenn Ingram. I've been working for I keep saying better part, for 2 decades, helping
Has it
people.
been better? Has it been better?
Well, it's always that it hasn't been that long if I say better part.
Okay, I get it.
Trying to help people become better influencers. So being able to be better communicators and better listeners. Kyle, good morning. How are you?
Good morning, Paul. Good morning, Glenn. Thank you for having me. My name is Kyle McGinn, and I'm an attorney with the McGinn Law Firm in Council Bluffs, Iowa. I believe I get to join you gentlemen today to discuss a burgeoning topic, estate planning. It's one of the several areas that I and my firm have practiced in. My firm has been in existence since Council Bluffs, Iowa, since the year 1914. My great-grandparents actually started this firm. It was founded by my great-grandfather, a gentleman by the name of Albert McGinn. His wife joined, and amidst having 10 children, she became his chief paralegal, deciding that at that time, this didn't seem all that terribly difficult when compared with having 10 children. She sat for the Iowa bar examination, passed, and then I suppose like in the state of California, was admitted without ever attending formal legal education. So we've been in existence for 108 years. I'm the 4th generation of our family to work here. It's a wonderful legacy. I've been in practice for some 7 or 8 years now here, all exclusively with the firm, and intend to remain here as long as they'll have me.
Nice. Well, after giving us a little bit of that history, Kyle, It sounds to me like your grandmother felt that estate planning was no more difficult than meal planning on a daily basis, especially for 10 kids. The topic of estate planning is, it sounds like one of those things that people just drag their heels getting around to, that old joke of around to it. Here's around to it, because eventually you get around to it. And when is the good time? What are the good steps to take? Because not everybody is near retirement age who's watching Blabbit right now or watching the rerun of this. But I have a sneaking suspicion that you've got advice for people prior to that phase in their lives. So what would that be in terms of planning, beginning of planning?
Without question, Paul. And I think another common misconception or myth that I confront is that estate planning is only for kind of the super wealthy. Many of us are in the kind of the broad middle class, and we're not sure or certain that estate planning affects us or that it's necessary for us to engage in estate planning. I always, in a strive or an effort to achieve political balance, remind folks that your last name doesn't have to be Trump or Buffett to engage in the estate planning process. It has importance for all of us. I see people at 2 central junctures in their life, I would say, 2 large tranches. The first is, approximately age 25 to 35 or 40, when, folks settle down into their career, perhaps into a longer term relationship or marriage, and perhaps start to have some children. In any event, likely to start to accumulate some income and wealth. They're not just living out of the back of their truck, moving into out of a dorm or a short-term apartment or something at that point. So they start to feel that need more urgently. So that's the first central time where I really start to see folks. I start to, again, kind of revisit with some of the same clients a few decades down the road, hopefully, when they have started to lose loved ones, whether that's family, friends, somebody close to them, and they're reminded of the necessity perhaps to revisit those earlier documents that they haven't done, or perhaps those earlier documents that they had drafted a couple decades ago to make sure that they're still appropriate. And if they haven't gotten around to drafting anything, then they've been a little bit tardy, perhaps in their responsibilities to drafting a document. They put that off because it can sound perhaps as fun as going to the dentist's office. Then I see a lot of folks for the first time at that juncture. But many people I deal with, maybe into their 50s and 60s, and they've started to lose a parent, unfortunately. And perhaps their parent wasn't as capably planned as they could have been, and they're confronted with a little bit of a mess in their wake. And amidst the grieving process, they've also got to, unfortunately, kind of unwind some of their financial legal affairs. And that can be really challenging. I think that's one of those times in life where people are reminded that life is so wonderful, but it is so fleeting. And that the mature, responsible thing to do is get a plan in place. Even if you don't want to confront the issues, if you don't want to think about them, then for the benefit of whomever it is that you're going to benefit after your life. It can be an unpleasant conversation. I always try to approach it with as much levity, compassion, and understanding as possible. And I feel like that's reciprocated by my clients.
Well, and do you ever find that some people think, oh, I don't need to do this now, or B, I don't have the net worth to worry about this?
Absolutely.
That they always should start planning this, because as one attorney has said to me, and I think I've shared this with you in the past, if you don't have a plan for when you pass away, the state of fill in the blank has one for you. It's called probate.
That's exactly right.
That's right.
I guess I should commence or say at the outset that I'm licensed in the states of Iowa and Nebraska. That's where I practice. A lot of the concepts that we're discussing are in no way exclusive to the states of Iowa and Nebraska. I know you gentlemen have a national scale audience, and so I think we can have a generalized discussion that will provide broad scale advice or information for folks, and they can of course speak with a locally licensed practitioner to help them kind of get those documents in place and hopefully have a more knowledgeable conversation with those persons whenever it is that they do get around to scheduling that appointment. So obviously none of this, of course, is specific legal advice that anybody should rely upon, but it's more broad-based information that hopefully informs those particularized conversations that you can have about your family situation. And I guess I should say to that vein, none of us have very few of us have a classic or nuclear family situation any longer. Many of us have multiple marriages or relationships throughout our lives, stepchildren, adopted children, maybe just special persons that we want to care for. When you're having those discussions with your practitioners, it's not the time to be bashful. It can get rather intimate rather quickly. Someone books a consultation with us over the telephone or in person, or their legacy client, and I'm meeting them for the first time. And within minutes after I'm getting to know them, we've got to have fairly intimate discussions about their assets and holdings. That can be challenging, both as a practitioner and as a potential client or a first-time client. But it's important that you approach that conversation with openness, that you come prepared to discuss some of those details. It's a relationship that's built on trust and honesty and open communication. And I can only assist folks if I get transparency. A question I get a lot at the outset is, what should I bring to that first initial meeting? What do you need? That's a question I get all of the time when people are booking kind of a first meeting with me. The answer is, it is helpful to have that broad picture. For most persons, their wealth is kept in a couple of areas, perhaps. That's equity in their home and retirement accounts. The retirement accounts oftentimes can be distributed by a beneficiary, the same as kind of like on a life insurance policy. So they may or may not be included, in the estate plan or the trust. Having a whole ecosystem view of a person's wealth, whether that's again their home, their bank accounts, their vehicles, their personal property or collectibles that they may have at their house, and their retirement accounts, life insurance policies, it's important that they come prepared with all that information. It may not be important that they have exact dollar amounts, but institutions and beneficiary information is important. Of course, the dollar amounts are very likely to fluctuate. Lord willing, your home, your assets will continue to appreciate. And so the numbers will change by the time that your beneficiaries get around to receiving those items. And very likely, fortunate to live long enough, you'll draw down on some of those assets to live for retirement income. So those are some of the things that a person should be prepared to have when they book that first appointment with the practitioner and show up.
So is it more, or rather, is step number one, or the motivation that brings people to your office to do estate planning, I've got to have a will so I don't give it all to the state? Is that step number one? Is that the motivation for most individuals to book
Sure.
that appointment?
I think that, and Glenn had pointed to this. If you do not make a plan, the whatever state you happen to reside in will gladly supply one for you. That's
Yeah.
kind of the classic plan as you could imagine. If you're a married person, then everything to your spouse, and then to your children. Uh, the problem may become it doesn't indicate who the fiduciary should be. Meaning, if you don't nominate somebody to take care of this, somebody has to step forward that may or may not be the person that you think is appropriate to handle that. I think that's one of the most important facets of the estate planning process, whether you use a will or a trust or some other device, is establishing who are the persons that are going to handle these matters after I am no longer here to do so myself. Obviously, that needs to be a person of great
Mhm.
trust because they're going to be put in a fiduciary capacity where they're going to have great power. In some families, you're not going to have that person. You're not going to have someone that's maybe experienced or savvy with financial or legal matters, or perhaps you just you don't have anybody that's in the sake of a younger family. You don't have anybody that's quite old enough yet in your family to adopt those roles. So I think people approach me because they know that they've got a vague need. They are concerned that if they don't do something, the default plan may not work for them, or that their money will go to the state. It's very unlikely that their money actually goes eventually to the estate. You would almost have to have no living family. So we can debunk that notion rather quickly. But
Mhm.
it's important that you have a customized plan that suits your desires, interests, needs, and perhaps almost as important, that you designate the proper individual or organization to serve as your fiduciary and conduct your plan, administer your plan after the conclusion of your life.
Well, after you organize something like that, are there ever emotional reversals based on conversations within families? I mean, I don't want to make this sound like Dallas or a primetime soap opera, but it sounds to me like you may have experienced firsthand some hand wringing that goes on.
Without
Can you tell us
question.
about that?
Yeah, absolutely. It's a natural time where family units revisit the history, tensions, rivalries that have uh, been created over the course of decades.
Yeah.
Some of the most challenging conversations, of course, I have are with maybe parents who are deciding whether or not to include or exclude children in their estate plan
Mhm.
for whatever reason. And certainly, I and my fellow practitioners, we hold no judgment. I trust that my clients don't make these decisions lightly. They've formulated those decisions over the course of months or years, most often, and that's not something they take lightly. I would offer to your viewership that fortunately, most of the plans that we create, whether that's a will or a revocable trust, and we can certainly explore the differences and some of the early pros, cons of using either of those devices, but most of those can always be changed. So, assuming that a person has the sufficient competency, meaning that they maintain the baseline mental and emotional ability to make changes to their plan, they
Mhm.
can always revisit that plan later should their relationships change. So, should somebody be divorced? Should somebody pass away? Again, assuming that you have that baseline ability, you can go back with your practitioner and make whatever amendments or revisions are necessary because life happens. I always tell folks, hey, give me a call. There are some offices that will schedule regularized visits with folks every year to ensure that their plan is still valid and appropriate. Some
Mhm.
practitioners will handle it that way. I always tell folks, give me a call in 5 years, or if a major life event like a death, divorce, something like that should occur, or just give me a buzz if you have any questions about the impact of any of those activities on your plan in the interim. I'm always happy to serve as a resource. We try to draft our documents with as much flexibility as possible, but certainly we can't anticipate every change in circumstance that could arise after we're done executing those documents.
Now, you talk about change in circumstance. I just wonder if you run into situations where people don't think about their estate, their life insurance policies, all these different things when they have little things like a divorce. I recall about a decade before I left the Midwest, going to a friend of mine's funeral, fell down some stairs, and all of a sudden, in the next week or so, found out that his current wife was not very happy that his ex-wife was the beneficiary of his life insurance policy.
Yeah, that's one of those times where you absolutely want to revise your plan. Is in the case of a divorce. Most states have a statute which indicates that upon a divorce, if your spouse or your ex-spouse is then still listed as beneficiary, that despite that beneficiary designation on whatever investment asset or insurance policy, by virtue of having a decree entered, we recognize that was an inequitable result, and we're gonna overcome that. But I wouldn't leave it to that chance. Absolutely, if you're going through a dissolution of marriage, formal term for divorce, that is a very important time to revisit your estate plan.
So you bring up an interesting point, that being that, well, in the case of a divorce decree, we're going to override what that document says. How ironclad is anything at that point? I understand there's flexibility built into things, but let's say, what reassurance do we have once we are gone that our wishes are followed through on?
Tremendous question. We try to ensure in that drafting process that the documents we've created will survive the drafter, and that their wishes will never be disturbed. There are a couple ways that we do that. If a person perhaps has been seeking recent medical treatment, and a lot of times this is an older person, but it doesn't have to be an older person. If they're presently undergoing medical treatment, it's my practice and the practice of many other attorneys in this discipline to consult with their medical provider prior to and as close prior to them drafting those documents as possible. And it's kind of an interesting question, because ultimately the determination of competency falls to me as the attorney. Now, I have a Juris Doctor. I have no medical doctor license. So I always find that I would defer to the person's health practitioner that they've been seeing. I will author a letter to their health practitioner, include an authorization for release of medical information, and ask the health practitioner, in light of the existing standard for competency in this specific jurisdiction, which is as follows: do you think that John or Jane Doe has the standard baseline ability to render legal decision making at this time? I will tell you that the baseline is not a very high threshold. There's simple things like, do you know who you are? Do you know what you own? Do you know who are, quote, the natural objects of your bounty? Who do we as a society and the law believe that you would likely give your things to? That doesn't mean that you have to give your things to those folks. But, if you're a married person, if you have children, very likely we would expect that you would include those folks. So do you have that baseline competency to understand those things? In my experience, medical practitioners are fairly reticent to indicate that their clients or their patients, our clients, our common persons we're assisting, don't have that competency. And again, as I always tell folks, I don't need you on your best and brightest, on your day of graduation from high school or college or your professional program. I just need you to have that baseline level of competency that assures that I'm comfortable as a practitioner drafting those documents. So that's one thing that we can do if we anticipate that perhaps some in the family or some other beneficiaries included, excluded, or included or excluded to a different degree may have some rumblings after a person passes. The other thing that we can do is include certain clauses in the will or trust that would discourage a will contest or challenge after somebody has passed. They're called, because this is a podcast in regards to legal matters, we ought to include some good Latin phrase somewhere in the course of this hour. It's called an inter orum clause. For those of you watching it at your homes or workplaces or over your lunch hour, you can Google that. Interorem, 2 words, interorem. Interorem means if you do not have probable cause. Now, I know that's odd to use the term probable cause in the context of a civil or estate or trust matter. That's normally or more commonly a phrase that you would hear associated with criminal law matters. But if you do not have probable cause to commence a challenge against someone's will and you bring an action, then you are to receive nothing. So if a testator, which is a person that drafts a will, or a settlor or trustor, which is a person that drafts a trust document, anticipates that there might be some grumbling because of the plan that they've created. And most commonly, I'd see that because, again, one of their anticipated beneficiaries, perhaps a child, is excluded or is included, but to a lesser degree or extent. And we could anticipate that there's going to be perhaps some strife or disagreement after that person's, after that person's passing. Then those are the kind of proactive steps that we could take to ensure that their plan is best protected as possible. So certainly nothing is ironclad. However, should you follow those steps and perhaps even tape the execution of their documents? I've heard of that occurring too in an audio or video file to demonstrate with certainty that the person understood the effect and the gravity of the things that they were doing. Those are the absolute best ways, regardless of where you're situated and where you're executing documents, to protect those. And local practitioners can advise you on those. But those are some of the things that we do to make sure, as nearly close to possible, that it is ironclad.
Mm-hmm.
Now, you mentioned where you are. To the best of your knowledge, are there certain places in the country where maybe the probate system is slower, is more difficult to work with, is more important for someone to have a will, a trust, and estate plan than others?
Sure. So again, I practice in the states of Iowa and in Nebraska. My experience is that the probate system here is relatively functional. And by functional, I mean it's relatively fast. Obviously, what we're striving for is to always transfer assets as quickly and efficiently as possible. And by efficiently, I also mean as low cost as possible. I understand from some of my colleagues in other jurisdictions, like the great state of California, Glenn, that the probate system there, perhaps just by virtue of sheer population and numbers, it can be lengthier, more costly, that the attorneys and court costs can absorb more of a person's estate. Obviously, that's something we want to avoid if at all possible. One way of probate avoidance, or commonly employed, is a revocable trust. If it's properly funded, and by properly funded, I mean that assets are properly retitled in the name of the revocable trust or irrevocable trust, whichever document you're creating, then you should need minimal, if any, court involvement. The assets, instead of being administered by a court, are going to be administered in accord with the provisions of the trust document that the individual created. There may be some small need for court involvement kind of at the margins, but it removes that overarching need to administer the terms of somebody's will. That is the number one reason that folks solicit us for a revocable trust agreement. And it's cited probably as the number one benefit of a revocable trust is speed and efficiency. We're blessed with wonderful judges in this country, but the less that my probate clients have to see of them, the better. That's just going to save them time and money and make sure that, their lives are as simple as possible moving past that. There is, please, pardon me. Go ahead, Paul.
Yeah, no, just a quick question, and that is clarification of terms here and also of system and the procedure. Does every will go through probate?
Great question. Yes, the answer is I'll give you the classic law school professor answer. It depends. Not every will go through probate, only because a person at the conclusion of their life may not have assets that need to be probated. So I would say the most common example of that is perhaps between married persons that have companion mirror image wills. If married persons, own all of their assets jointly, so they have joint bank accounts, they're joint on their vehicles, they're joint on their residence, and they're primary beneficiaries on one another's life insurance policies or investment assets, it's almost certain that they do not need to go through the probate process. However, anytime that there are assets that do need to be administered by a will, you are into the probate process without question.
Okay.
So that's the idea. The will has no effect or life until it's admitted to the court properly and overseen by the judge. You're taking, by drafting a trust, some of that work that would occur after a person's life and fast forwarding it to present day. By drafting a trust, you're creating a separate legal entity. Now, most often, the drafter of the trust retains ownership and control over those assets until they are either incompetent, unable, injured, or deceased. At that point, that duty of management falls to the next person or the next trustee in line. The trust obviously has also successor beneficiaries. So the first beneficiary is the person that created it. They want to retain ownership, they want to retain control, and they want to retain all the benefit. After they are perhaps incompetent later in their life, somebody else, maybe one of their children, succeeds ownership, and then after their life, succeeds as management capacity, and then after their life, they succeed to ownership. So you're taking some of that work that you would otherwise be done under the supervision of a judge after someone's life in that probate process and bringing it up to present day. No surprise, there's a little bit more paperwork and time involved in drafting a revocable trust because we are taking some of that work that's done under court supervision after someone's passing and bringing it into the present day. So you're always or almost always going to draft a companion will that says, oh, by the way, anything I forgot or that somehow ends up outside of my trust, please administer that into my trust, Judge, if that should happen. That's another will that we hope never sees the light of day. And you're also drafting a deed most times to transfer ownership of anybody's real property into their revocable trust. So there's a couple of additional items of work that aren't necessary when someone's drafting a trust that are necessary when that aren't necessary when someone's drafting a will that are necessary when someone's drafting a trust. So there is a slight disparity in cost. The idea being that getting some of that work that would otherwise involve the court out of the way and bringing it to present day on the net should result in a significant cost savings to the person that's doing the planning and their estate or beneficiaries.
Okay.
Now with wills, I would like to ask a question a little bit more about like a living will. Because
Yes.
as most of us out there, I attain most of my legal knowledge by watching evening television shows. So I've heard about someone having a living will and who was making determinations of what would happen to someone when they are no longer able to make decisions for themselves.
Sure.
So is that when a living will comes into effect?
Glenn, a tremendous segue. One of the things, everybody comes to me thinking about wanting to talk about that period of their life or the period after their life. They want to talk about wills and trusts. They want to talk about, here's the people that are important to me or the organizations or institutions or causes that are important to me. And here's the people or organizations that can get the things, whatever should remain into a person, into the right people's hands after the conclusion of my life. I try to always refocus people on that period of their life that they're going to need maybe some additional assistance. It can be a challenging conversation because we don't want to confront the idea or notion that we're ever going to need assistance. We're a very independent society. Even with a close family knit unit or close friends, we don't want to have to rely or burden anybody with additional responsibilities for our health and our well-being and legal and financial decisions. But I always try to refocus people on that period during their life should they need additional assistance. That comes in the way of powers of attorney, which is what you referenced. Now, in almost every jurisdiction, there's two different powers of attorney. There's a power of attorney for medical matters, and that almost always is drafted with or in companionship with a living will. And the nomenclature here is really important. The terminology is essential. A living will is completely different document than a last will. A last will, of course, governs what happens with your assets or property after your life. A living will instead determines, here's how I want to be treated at the end stages of my life. It should be carried out by your medical power of attorney or your loved ones, whomever is charged with responsibility for your medical decision making in those end days, weeks, months of your life. It says, again, the medical power of attorney is the person that is tasked with making those decisions for me if I'm unable or unwilling to make those decisions. The living will most commonly says, if I have an irreversible condition that's going to lead to my death within a relatively short period, or a permanent vegetative state or a period of unconsciousness, what kind of care do I want to receive? I well understand that that is informed by every person's individual philosophical, spiritual, religious, ethical, moral beliefs. That informs them as to what they think is appropriate on that decision. Anecdotally, in my experience, the vast majority of my clients will indicate if my doctors, in consultation with my medical powers of attorney, arrive at that decision, it's my preference that I receive palliative care only, that I be kept comfortable and free from pain, that my physicians are instructed to offer me the high quality pharmaceuticals that our country can produce to alleviate some of those pain symptoms. But I otherwise want the natural dying process to occur, meaning I want to receive palliative care and nothing more. Folks ask me, well, what do most people do? And that's true not only in the context of a living will, but in the context of all their estate planning documents. Again, I'm reluctant to tell them because I don't think these decisions, which are so intimate and critical, should be left to the whims of the majority. But the majority of my clients do select that. I have some, like I referenced, with strong religious, ethical, moral beliefs or spiritual beliefs who want a more nuanced kind of set of instructions or care, and we're always happy to help folks draft or craft that. The living will, I think, really came to the forefront publicly through the difficult Terry Schiavo incident. I believe that was in the state of Florida, where the woman was very ill, and her husband, I think he was either estranged or an ex-husband, was charged with making decisions from her care, and he got at odds with her family over what's the proper course of action. It's really important, I think, that is laid out in advance, so that person knows how to operate. Again, the other document is the statutory or financial power of attorney. That document allows somebody else to govern your legal or financial decision making for you. Many times, folks will make that a springing power of attorney. That springing language means that it only has effect when your physician certifies that you are unable or unwilling to make those decisions for yourself. So again, if you suffer some injury, illness, incapacity, your doctor authors a simple letter, it's affixed to that power of attorney, and the power of attorney springs to life because you may or may not be comfortable with whomever is nominated in that document, assuming immediate control. But it can be drafted in either way. I will tell you, both of those documents are critical for easy, efficient decision-making at those challenging times in life. They're very inexpensive and simple to prepare, and they save your family the possibility of having to create a guardianship conservatorship to make medical, financial, legal decisions for you. A guardianship conservatorship, again, gets us back into the court system, and it may be necessary to do if somebody's going to live for a period or has some assets that need administering. Again, it's slower, it's costlier, and it can be very simply avoided with powers of attorney. So I would absolutely suggest that while you're undertaking this estate planning process, to get those cheap, easy documents drafted, your family will thank you immensely if they become necessary.
Sure. So let me weave a little sci-fi into this episode of Blabbit.
Sure.
Have you experienced people who go, nope, keep me going as long as you can, or even worse, freeze me? Do you ever get any of that?
I have, and there I think folks, when we start discussing that, are worried that maybe their children. We always kind of joke, well, they'll be eager to pull the plug as soon as the doctor gives them the green light. They're over there at the wall pulling it out of the outlet. In my experience, of course, because of our wonderful plaintiffs bar across this country, medical care providers are extremely conservative in their course of treatment, and that's not really a legitimate concern or care. Kind of an interesting item you hit on, Paul, which is kind of at the forefront of our discipline, is because of the wonderful advances in modern medicine and science, we've got a bunch of new ethical, legal quandaries around organ donation, preservation of your body. One matter I'm dealing with presently is the preservation or of genetic material after somebody has passed, and courts across the country have started to confront this. With modern reproductive methodologies, somebody may pass, but their ability to create life may not extinguish with them, and we as a society have to confront the idea of what should be done with that genetic material that they leave, and whether it's appropriate after the conclusion of their life that genetic material end up in the possession of somebody else, or whether it be destroyed, or how exactly to navigate that situation.
It's like Tales of the Rue Morgue.
It's
I hate to be glib. I hate to be glib about it, but it's just wow. You got to deal with some stuff.
Well, that's a burgeoning, obviously, again, highly emotionally charged facet of the estate planning, and it arises perhaps certainly more commonly now, but irregularly enough that courts are oftentimes confronting these developing issues for the very first time. So that's while this is obviously longstanding practice, humans have been passing away and bestowing possessions for thousands of years, and we've got a fairly developed practice or procedure for doing so. These are some of the areas right at the forefront that are fed by the changes in modern medicine and technology in the estate planning context that can be really important. I only anticipate will be more important as the science advances.
Sure.
So when it comes to kind of having one captain, one person kind of making sure that everything is pointed in the right direction, how important is it, and I know this, I'm leading you the question, I'm throwing up a lob ball, to speak with an attorney when you're talking to your banker about adding beneficiaries to accounts?
Oh,
when
wonderful.
you're having a life insurance about having beneficiaries, just to, again, make sure that all I's are dotted, T's are crossed, and everything's going to happen with the least amount of problems. Because in my experience, the best part of people typically don't come out after a family member passes away. It's
true. And everybody, as my mom is fond of saying, everybody gets a pass in the wake of a tragedy like that. And it's difficult when you're confronting the emotional trauma of losing somebody that you love, and you're also tasked with, hey, they've got a residence, they've got payments that are coming due. How do I access their accounts? I'm lost. I don't, I may have some sense or semblance of where their assets are kept because they've been open with me about that, or I may not because the person was more private in nature and didn't feel comfortable disclosing that information. There's different levels of disclosure in different families. I would encourage families to be open and honest about these things. In the context of your estate planning, I always encourage folks, please, for the benefit of your children who don't know as much as you think that they know, generate a listing of your assets that does not have to include account values or numbers, but generate for them a listing of your assets, who they should go speak with, give them the roadmap, make their lives easier. That oftentimes includes, as you referenced, perhaps your life insurance company and account number, your bank or banks and account numbers, perhaps your vehicles, your real property, your plan administrator, any financial professionals that you work with, and obviously your estate planning attorney.
But then also, does that include, and I know this is absolutely a novice question, but along with passing that information to your heirs, do you have to pass along passwords and access when you talk about making it a free road? That can be a little befuddling too, and it can slow the whole process down.
It absolutely can. And you kind of hinted at another kind of burgeoning or interesting area of estate law, Paul. It is helpful because so many of our assets are kind of now digitized, and we've got a social media presence that may continue after our lives. Certainly, you can approach the Facebooks and Twitters and Instagrams and LinkedIns of the world if you've got the sufficient authority on behalf of somebody's estate and deal with that digital asset that perpetuates after somebody's alive. You may have access to their Gmail, Yahoo Mail, whatever email service that they utilize account. You may have access to their bank accounts. You may not have these things. I do think it's helpful to create a repository of that information. And if you're not comfortable yet sharing that and tacitly granting that individual access to those services, then create that on that protected document that we've discussed. Include that and close that with the rest of your estate planning documents and put it in a safe place. And just let somebody know where that is. How they can gain access to those after your passing. It's not common. It's not common or necessary in this area, and I don't believe it's really, frankly, common or necessary in many areas to file your will with the court system. There are certain select instances where that's appropriate or necessary, but most commonly it's not the case. That's another kind of common question that I receive in the course of this process. Some folks will put it into these documents and perhaps their password or their spreadsheet financial document that I discussed or referenced. They will put them into a safety deposit box. That's a wonderful repository. However, please make sure that somebody knows where that safety deposit box is, because I've had instances where somebody says, well, I've got a safety deposit box in Omaha, Nebraska. Wonderful. Maybe even they can name a large-scale national bank that it's at. Wonderful. Well, they've got 7 or 8 or 10 branches, and certainly if you're located in New York or California or Nevada, they may have a great many more. So let's make it easy for these folks to go find that information and obtain access so that they can get on with their job of processing your affairs. Kind of, again, an interesting burgeoning area. Folks have a lot of digital assets these days. How do we deal with cryptocurrencies or other NFTs or other digital assets that folks may leave in their wake? That's all part of their estate, and it all needs to be planned or plotted for. Again, kind of a non-traditional asset or that people may hold, but as people start to develop more wealth in those areas or invest more into those areas, it needs to be planned for or plotted for, and that's something that your beneficiaries need to be able to account for.
Okay. I have another question about just a clarification of terms.
Yes, sir.
You used the term very early in this broadcast about somebody taking on a fiduciary capacity or being a fiduciary. Is that the same as the executor of a will?
Wonderful question. Yes, it is.
It is. Okay.
Fiduciary includes executor. Fiduciary also includes trustee. It may include a conservator or a guardian. That's someone charged broadly with a fiduciary duty, a duty of loyalty and fidelity to the person that they're serving. So yes, an executor is a fiduciary, but it's only one of many fiduciaries, including trustee or guardian, conservator, some of these other.
Now, what happens if you set up your will and you've determined, you have delineated very clearly who the executor is, but then for whatever reason, before your passing, they can no longer provide that, fill that role?
Yep.
What happens at that point? Do you have to go back in and redo, or does it get passed down automatically? What happens there?
Great question. So most commonly that's addressed in the planning process. So you'll put a couple of nominees. So early in a person's life, oftentimes that'll be maybe a sibling or a parent. Later in their life, maybe it's one of their children. It is a good time to revise if you've got enough time to plan for the fact that that person is either no longer living or maybe he's gotten older and aged, and it's just not appropriate for them to accept that level of responsibility any longer. So if it should come to pass that it hasn't changed, then it would fall to the next person in line. Now, nominating somebody as your executor in your will does not require them to serve. So if I'm named it in your will, Paul, but it should come to pass that I'm just too preoccupied or we've fallen out of favor or whatever, I could always decline to serve. So it's just a nomination. It's not ironclad. If for whatever reason it's not a good fit at the time that the person should come to pass, they can always choose, most often by way of a written resignation, to refuse the nomination.
Okay.
So when someone's looking to develop that list, what type of advice do you give them? And I ask that because I've seen 2 different times where people have established someone as the primary beneficiary because they were good with money, but maybe not the best at dealing with stress and loved ones. So what combination thereof is the best in your experience to be that executor?
Sure. And there's a couple, I'm going to broaden that a little bit. I'm going to include a discussion about powers of attorney. sometimes there are folks who are well suited to medical decision making that aren't well suited to financial or legal decision making, and vice versa. So when you're thinking about who to add into these various roles, think about that person's experience. One of the things that is helpful, though not necessary, is, of course, geographic proximity. It is oftentimes easier to administer somebody's estate or affairs when you are closer, only because a lot of times that includes cataloging somebody's personal property, making sale of what could be sold or holds value, and perhaps cleaning out or donating or trashing the rest. So geographic proximity is helpful, but it's not necessary. I've worked with co-executors all over the world who are helping me administer estates in the Midwest. Of course, that means you're likely going to have additional expense because you're hiring out some of those services that I just referenced, or you're going to have to seek additional assistance, kind of boots on the ground. So it may lead to some modest additional expense in the course of administration of the estate, but it is certainly possible. So geographic proximity is important. I find many people proceed in birth order if they're going to use your children. I'm a strong believer in birth order, probably because I'm an eldest child. So, hello, Corey, if you're watching.
Full transparency.
Yes, disclaimer. That's not necessary. I discourage folks from nominating multiple fiduciaries or multiple executors or trustees. Sometimes parents, in an effort to or strive to achieve balance or fairness, want to have everybody see their name included on various documents. I think it's preferential, and I've explained this to my clients many times, to have one decision maker. I understand that in most families, that's the result of broad conversations between everybody that are impacted or involved. But in an effort to prevent frustration, loggerhead, and ultimately court involvement at everybody's expense, I like to have one ultimate decision maker nominated to serve in whatever fiduciary capacity. There's no magic wand. You're not receiving any significant benefit. The executor or trustee, whomever is serving, is absolutely bound to abide by the terms of the document that the drafter of the will or the drafter of the trust has set out. They don't get to change anything. And there's no major benefit. As I tell folks, most often it's way better to free ride as a beneficiary than bother to have to serve in a frankly a low paying or non-paying second job in processing somebody's affairs. It's going to result in a lot of time, maybe cataloging someone's home, or at the very least on the phone with talking to various folks, attorneys, utility companies, credit card companies, et cetera, and unwinding the affairs of somebody's life. So you can, in most jurisdictions, seek a modest stipend for those for those efforts, but many elect not to. And again, in any event, it's usually modest unless it really unfolds into a significant undertaking. I'll tell you, at the outset of many estates, folks will tell me, or trust administrations, folks will tell me, no, I don't need to be paid. It's no big darn deal. And then perhaps some 6, 9, or 12 months down the road, they're thinking, wow, this was a bigger deal than I expected. Yes, I would like to be compensated for some of my efforts, which is absolutely appropriate.
Let me offer up a hypothetical situation, which probably isn't hypothetical,
Sure.
But that is you are someone over 50, you have adult children, okay? And there is some contentious relationships for whatever reason. There can be a whole variety. It can be a whole variety pack of contentious relationships between the children. So you write up a will and you make your best educated and advised decision about who to make the executor.
Sure.
Do all of the children have a right to see that will and see what decision you've made? That's question number one. I have a second.
Okay. We'll address number one. Nobody has a right to see the contents of the will until it is presented to the court system following somebody's passing. Okay. So, many times, especially in pop culture, we'll see the reading of the will in the dark oak paneled attorney's office.
Yeah.
It's unusual that I conduct such a formal setting because it's really truly not necessary. Most times it's just distributed, whether that's a printed copy or an electronic copy.
Yeah.
At the outset, it may be helpful for all of the beneficiaries to gather in my office to demonstrate that there is openness and transparency, and that despite the fact that I'm going to be working most closely with the executor or trustee, that I'm open to all of the beneficiaries. The council always has an obligation of impartiality to all persons involved. So if you're watching and you are a beneficiary of an estate or a beneficiary of a trust, then please call the attorney. They should respond to you as well. They are representing the estate and not the executor or trustee's individual interest, so they should be open to you. So after the estate is opened or the trust is administered, then all of the beneficiaries should receive a copy of the documents. And particularly in a estate proceeding, they're going to be getting notice at several junctures, and they'll be able to closely track or follow the progression of the estate proceedings.
Okay. So question number 2. What if you're the type of person who, even in passing, doesn't want to create a conflict situation? Do you opt not to have a will, or to choose rather to create a trust that is in some other person's hands, some other individual, a professional is the fiduciary?
Sure. In some families, you may not have somebody that has the time or ability or perhaps experience or education that lends themselves to serving as a fiduciary, an executor, or a trustee. In those kinds of instances, I oftentimes look to what's known as a corporate fiduciary. And a corporate fiduciary most commonly is a bank trust department. In some scenarios, it's an excellent fit. There's also just persons who are maybe single persons. They've chosen not to have a family, a spouse or any other children or whatever, and they don't want to burden their friends or their siblings perhaps with that responsibility, and they'll use a corporate fiduciary. Yes, they do charge for their service. No surprise, they are a bank after all. But in many instances, they're an excellent choice because they approach it in a non-emotional, professional setting, and they have experience in processing estate affairs. They are also going to work with estate counsel or trust counsel to administer in accord with the terms of the estate or trust. So my experience has been in the circumstances where they're necessary, they're a tremendous resource, and it's a high value that you obtain from their services.
Right.
Believe it or not, our time is coming to an end.
Wow.
I think Kyle's wife's right. When he talks, I just kind of lose track of time.
But I'll tell you, that was very educational, very enlightening, Kyle, and really quite not something that I have to say, you are a unique guest expert. You really are. And this was really interesting information, often information that you don't hear every single day. You don't see people lining up to tell you what the most trendy way to set up your will or your estate is, but it's solid information that everyone needs to know. So we really appreciate you sharing that with us here today on Blabbit.
Gentlemen, I appreciate the opportunity to be with you. I could go all day on this topic. Again, like I mentioned earlier, I hope that this has offered some baseline education to both of you and to your viewership, and that they can follow up. If they're local, we'd be happy to assist them in Iowa or Nebraska. If they're elsewhere in the country, I would encourage you to promptly consult a practitioner. It's going to be less intimidating or frightening than you think, and less costly, I promise.
Well, I think you have made that abundantly clear with your wonderful personality and your ability to put everything into such an anecdotal fashion and allow us to process it and absorb it as we should. So, Glenn?
If someone is in Iowa or Nebraska and would need a little bit further of assistance or would like to inquire, what's the best way to reach you?
My telephone at our firm it's a 712 area code, 712-328-1566. My email and telephone are both, of course, on our website, which is maintained by our wonderful SEO assistant extraordinaire. And it's McGinn Law Firm, all one word, nothing funny, no underscore. but McGinnLawFirm.com.
Excellent.
Awesome.
Well, thank you so much, Kyle. We appreciate you being here and being a part of Blabbit. Glenn, will you sign us off, please?
Yes. And I think we mentioned at the beginning, we maybe need to mention at the end that this episode of Blabbit is brought to you by Open Doors, your professional podcast coaching and consulting company.
That's right. We have sponsorship.
Everyone, we'll see you back here. Same bat time, same bat channels next week. Take care, everyone.
Enjoy, gentlemen. Have a